Welcome to meeting number 29 of the House of Commons Standing Committee on Industry, Science and Technology. Today's meeting is taking place in a hybrid format pursuant to the House Order of January 25th, 2021. The proceedings will be made available via the House of Commons website. So that you are aware, the webcast will always show the person speaking rather than the entirety of the committee. To ensure an orderly meeting, I'd like to outline a few rules to follow. Members and witnesses may speak in the official language of their choice. Interpretation services are available for this meeting. You have the choice at the bottom of your screen of either floor, French, or English. Please select your preference. A reminder that all comments by members and witnesses should be addressed through the chair, and that when you are not speaking, your microphone should be on mute. As is my normal practice, I will hold up a yellow card for when you have 30 seconds remaining in your intervention, and I will hold up the red card for when your time for questions has expired. Please make sure that you are on gallery view so that you can see me waving the card. Pursuant to Standing Order 1082 and the motion adopted by the committee on Friday, March 19th, 2021, the committee is meeting today to continue its study on the proposed acquisition of Shaw by Rogers. I'd like to now welcome our witnesses. From the CRTC, we have Mr. Ian Scott, Mr. Scott Hutton, and Mr. Christopher Seidel. From the Competition Bureau, we have Matthew Boswell, the Commissioner, Anthony Durocher, Deputy Commissioner, and Lila Wright, Associate Deputy Commissioner. And from the Department of Industry, Eric Dagenet and Adam Scott. Each witness group will present for up to 7 minutes, followed by rounds of questions. With that, we will begin with the CRTC. You have the floor for 7 minutes. Mr. Scott, you're on mute.
I thought it was turned off automatically. My apologies. Thank you, Madam Chair. I should note at the outset that I'm joining you from the CRTC's offices, which are located on traditional unceded Algonquin territory. I'd like to thank the Anishinaabe people and pay respect to their elders. As you mentioned, I'm joined today by two of my colleagues, Chris Seidel, who's the Executive Director of Telecommunications at the Commission, and Scott Hutton, Chief Consumer Research and Communications. We welcome the opportunity to appear before your committee as it studies the proposed acquisition of Shaw Communications by Rogers Communications. My remarks today will be short, and they will focus on explaining how the CRTC reviews transactions in the communications industry. I hope to avoid the red card during this appearance, Madam Chair. At this stage, I must say that we know little more about the potential transaction than does the public. We're waiting for the parties to file the required regulatory documents. So at this point, we only know what has been reported in the media and the industry press. I can, however, explain the CRTC's jurisdiction and the process we typically follow for these types of transactions. And specifically, there are two components to the proposed transaction. First, there's Shaw's telecom businesses, including its wireless and internet access business. And secondly, its cable and satellite television and video on demand businesses. Under the Telecommunications Act, transactions involving telecom services do not require the CRTC's prior approval. We have no role in approving transfers of ownership or transfers of spectrum, except to ensure that the company remains Canadian-owned and controlled, pursuant to the foreign ownership rules. Dans ce cas, nous réserve de la vérification.
In this case, subject to verification of the regulatory filings, Rogers is a Canadian company. I mentioned that the CRTC is not typically involved in reviewing ownership transactions for companies offering telecommunications services. Our regulatory oversight is on an ongoing basis to ensure that the services provided by these operators achieve the objectives set out in the Telecommunications Act, including the availability of reliable and affordable telecommunication services in all regions of Canada. I'm sure committee members are aware that we've undertaken an extensive review of the wireless market to ensure our regulations enable competition that provides better prices for Canadians. Similarly, we are currently conducting a review of the wholesale rates competitors pay to access the networks of the large cable and telephone companies, which they use to offer internet services to Canadians. I suspect you have questions about the outcomes of both these proceedings. I trust you will understand that we cannot speak to those issues, except to say that decisions are forthcoming.
Broadcasting assets in this specific case, the Broadcasting Act and its associated regulations provide that the CRTC approve a transfer of ownership of these assets. Once a completed application is received, we will publish a notice of consultation and we will seek comments from the public. We'll examine the proposed transaction, taking into consideration our relevant policies for the sector. And to be clear, this includes policies designed to ensure a diversity of voices in the broadcasting system and that Canadians have access to local and community television programming. And in this instance, we'll also consider the impact the transaction may have on CPAC, well known to many of you, which provides independent and nonpartisan coverage of Canada's democratic processes. As with all our proceedings, we will render decisions in the public interest based on the evidence on the record of that proceeding. The transaction, as you well know, is also subject to regulatory approvals from the Competition Bureau under the Competition Act and from the Minister of Innovation, Science and Industry under the Radio Communications Act. And my colleagues from those respective authorities are here with us today. So although I cannot speak about the matters currently before the Commission, as I've already mentioned, we will be pleased to answer any questions that you have. Thank you, Madam Chair.
Thank you very much. Our next presentation will be by the Competition Bureau. You have 7 minutes.
Madame la Présidente,
Madam Chair and members of the committee, we are pleased to appear today. Joining me are Anthony Durocher, Deputy Commissioner, and Leila Wright, Associate Deputy Commissioner in the Competition Promotion Branch at the Bureau. From the outset, it is important for me to clarify that the Bureau is required by law to conduct its enforcement work confidentially. Specifically, this means we are unable to comment on either specifics or hypotheticals, and we are therefore limited in what we can say about our review of this transaction. As this matter is under review, it would also not be appropriate for me to comment.
The feed is coming through equally with the same volume in both French and English.
Okay, thank you. I'll stop the clock. Mr. Boswell, could you verify if you have selected what language you have selected on the bottom of your screen? We're just going to double check to see.
I thank you, Madam Chair. I had it on English. I've just turned it off, if that's going to help.
If you're going to be toggling back and forth between English and French, if you could change it to floor, I think that will help.
Okay. The only options are off, English or French for the interpretation.
If you could put it on off.
Okay.
Thank you, and we'll if you can continue, we'll see if that works. Thank you.
Okay, I'll back up a tiny bit. Puisque cette affaire est en cours,
As this matter is under review, it would also not be appropriate for me to comment on what other witnesses in this proceeding may have said about the transaction. My remarks today will provide an overview of the Bureau's merger review process. The Bureau is an independent law enforcement agency mandated to protect and promote competition in Canada through the enforcement and administration of the Competition Act. The review of mergers is an important pillar of this work.
mergers of all sizes and in all sectors of the economy are subject to our review. Our merger reviews are conducted through careful consideration of evidence to determine whether a merger is likely to substantially lessen or prevent competition. This test is focused on market power. It evaluates a merger's impact on price, as well as on non-price dimensions, such as quality, service, and innovation. In its review, the Bureau collects and analyzes evidence, including interviews, documents, and data from the merging parties and a wide range of industry participants. Court orders can also be used to compel information. It is, of course, difficult to predetermine how long a particular merger review will take, as the Bureau evaluates the steps that need to be taken on a case-by-case basis. The enforcement decisions and resolution of issues will depend on the particular circumstances of the matter in question. Approval regarding enforcement decisions resides with me as Commissioner of Competition. But should a matter proceed to litigation, the ultimate decision resides with the Competition Tribunal and appellate courts. If I determine that a merger is likely to result in a substantial lessening or prevention of competition, I may apply to the Competition Tribunal for an order to prevent, dissolve, or alter the merger. Alternatively, I can negotiate an agreement that is enforceable by law with the merging parties without proceeding to litigation. I take this role very seriously. I want to assure this committee that the Bureau's review of the proposed transaction will be very thorough. I will make a principled and evidence-based assessment of its competitive impact and take appropriate action. We look forward to your questions today. Thank you.
Thank you very much. We'll now go to the Department of Industry. You have the floor for 7 minutes.
Bonjour, merci.
Good afternoon, Madam Chair. I'm Eric Dagenet, and I'm the Senior Assistant Deputy Minister, Spectrum and Telecommunications Sector at the Department of Industry.
Scott, who is the Director General for Spectrum Licensing Policy Branch. Thank you for inviting us. The Minister of Innovation, Science and Industry is empowered by the Radio Communication Act with due regard to the Telecommunication Act to govern the use of spectrum. As such, he may take into account all matters that he considers relevant for ensuring the orderly development and efficient operation of wireless communications in Canada. That's why we were invited today. Alors, pour nos besoins ici aujourd'hui,
For our purposes here today, the most relevant of those powers is the power to issue spectrum licenses, and that including reviewing and approving the transfer of valuable commercial mobile spectrum licenses between parties. Access to sufficient spectrum is a precondition to the provision of wireless services. Mr. Dagenet, I'm sorry. Would it be possible for you to move your microphone boom up a bit, please? That's better, thank you. Would you like me to start over? I'll just say access to sufficient spectrum is a precondition to the provision of wireless services. It is crucial to the digital economy and the expansion of next-generation connectivity.
we are guided by the Spectrum License Transfer Framework. We'll just call it the framework from here on in, which supports the government's policy objective, which is to maximize the economic and social benefits that Canadians derive from the use of the radio frequency spectrum resource, including the efficiency and competitiveness of the Canadian telecommunications industry and the availability and quality of services to consumers. The intent of the framework is to provide guidance to licensees as to how transfers of spectrum licenses will be reviewed, as well as introduce additional conditions of license regarding the transfer of control of spectrum licenses. Pour évaluer les répercussions
In making a determination as to the impact of a license transfer on the policy objective, ISED analyzes, among other factors, the change in spectrum concentration levels, that is, the amount of spectrum controlled by the applicants compared to all licensees that would result from the license transfer. Also, ISED examines the ability of applicants and other existing and future competitors to provide services.
Take into account the current license holdings of the applicants in the licensed areas, the overall distribution of license holdings of all commercial mobile spectrum bands, the services to be provided and the technologies available in the spectrum bands, the availability of alternative spectrum, the characteristics of the region, including urban and rural status, population levels and density, or other factors that impact spectrum capacity or congestion, and any other factor relevant to the policy objectives that may arise from the license transfer.
As stated in the framework, the application and supporting materials are treated confidentially. As once a decision is made, we will publish it on ISED's website. I'm happy to take your questions about the transfer process in general. Thank you.
Thank you very much. We will begin our rounds of questions. Again, just make sure that your interpretation is on the language that you prefer. So make sure that you have the proper interpretation service. We will start with MP Polyev. You have the floor for 6 minutes.
Thank you. I'm going to start with Mr. Scott. I'd like to do for those listening who may not be familiar with the overlapping and also divergent jurisdictions here, who does what exercise, because we have three approving bodies, and I just want to make sure we understand who is doing what. You did describe it, and you described it well, but I wonder if you might do it in point form, simply just a Coles Notes point form summary of all the decisions that your body, the CRTC, will have to approve or reject in this decision.
Thank you for the question, Madam Chair. Mr. Polyev, in point form, on the telecommunications side, we're responsible to ensure that Canadian carriers are indeed Canadian and qualified to act as such. So in this case, I think that is a moot point, subject to verification of documents. But the acquiring firm is Rogers, who we understand to be a wholly owned Canadian company, or controlled Canadian company. That is the extent of our jurisdiction with respect to the transfer of ownership on the telecom side. On the broadcasting side, Rogers and Shaw have a number of activities, and they require our approval. So their broadcast distribution undertaking businesses, their cable business, their video on demand business, licenses rather, Shaw's satellite delivered video programming, a BDU as a satellite operator, must be approved, and all of those require approval by the Commission. The transfer of ownership. That is a summary of the requirements with us.
And what, again, if you can do a Coles Notes version, what is the criteria upon which you would decide with respect to the broadcasting side? I think it's very clear, black and white on the Canadian ownership side, but the broadcasting, what would be the tests you would apply to make those decisions?
As I mentioned in my opening remarks, fundamentally, with respect to competition, we will want to look, well, not just competition, generally speaking, look at the diversity of voices. That's an important element of the broadcasting system. We generally are not prepared to allow one person, one company to control all television service providers in any given geographic market. It can include an assessment of the size of the affected markets and the market share of other television providers, and overall the competitiveness of the market. But as we've mentioned, with respect to a substantial lessening or not of competition in the telecom space, that is the responsibility of the Competition Bureau.
So what I took from that was mainly the diversity of voices is the major decision you have to make, whether or not this merger would limit the number of voices heard in the broadcasting space. Did I miss something?
No, I don't like to make forward-looking statements. I mean, once we receive all of the documents from the firms, we will issue a notice and it will identify any issues. But I wouldn't disagree with you that perhaps the fundamental issue to be considered on the broadcasting side is diversity of voices.
Okay, and it sounds to me like the foreign ownership side, that could easily be done by ISED. ISED has to make decisions about foreign takeovers in other industries all the time. Why do we need the CMHC doing this, given that ISED does it already?
We have different responsibilities under two different acts, and my colleague, Mr. Dagenet, might want to add to this as if he sees the necessity to do so. We're responsible for it under the Telecommunications Act. ISED is responsible for transactions with respect to the Radio Communications Act. And not to be cute, that was the determination made by parliamentarians. That's what's set out in the Telecom and Radiocom Acts.
Right. And, parliamentarians, of course, are always perfect, so that could not have been a mistake.
Exactly.
But if by chance in some theoretical world it was a mistake, is there any reason why if ISED does radio diffusion, it couldn't do telecommunication consideration of foreign ownership as well?
If I may, I'll try and answer the question in a slightly different way. I think, and if you think back, there was a regulatory proceeding some years back involving a quite elaborate process in the late 2008-9 period involving GlobalLive. One of the things that the Commission has easily available to it is the ability to hold public proceedings and public hearings as required. So perhaps in an area where there might be more controversy, the Commission has the necessary tools to hold a public hearing, which ISED lacks in terms of it's not a regulatory body that holds public hearings.
Thank you. Do I have any time at all? Okay, thanks very much.
Thank
you
you
very much. We'll now go to MP Erskine Smith. You have the floor for 6 minutes.
Thanks very much. I want to start with our competition commissioner, Commissioner Boswell. In a submission to the CRTC, the Competition Bureau wrote, mobile wireless prices in Canada are higher in regions where Bell, TELUS, and Rogers do not face competition from a strong regional competitor. Shaw would be a strong regional competitor, am I right?
Apologies, Madam Chair, I had to turn off my button. Yes, we discussed that in our submission to the CRTC's wireless proceeding.
Do you mind if I walk through a few more quotes? This one is of great interest to me because we had promised to produce prices by 25%, and the platform, obviously, pandemic has made that challenging in some respects in terms of priorities. But you note in the same submission, prices are in the range of 35 to 40% lower in the parts of Canada where wireless disruptors have achieved a market share above 5.5%. Shaw and its business freedom, that would be a wireless disruptor, right?
From the submission we made to the CRTC and the extensive reports that we filed, that is correct, sir.
You go on, wireless disruptors offer the most promising path forward. They drive lower prices, greater choice, and increased levels of innovation in Canada over the long term. If we see the loss of a wireless disruptor, would that be a challenge to lower prices, greater choice, and increased levels of innovation over the long term?
Well, what I can say, Madam Chair, to the honourable member, is that now that this transaction is before us, we will be required to conduct a thorough review and make determinations with respect to whether it's going to result in a substantial lessening or prevention of competition. And
I appreciate that. No, I appreciate it, and you don't want to get out ahead of yourself. So maybe we can look behind us. In the same submission you wrote in late 2017, the national wireless carriers engaged in a highly publicized series of price decreases to respond to Freedom's 10 gigabytes for $50 plan. Do you think the national carriers would have engaged in that publicized series of price decreases if Freedom hadn't existed?
Madam Chair, I simply, it wouldn't be appropriate for me to speculate as to what motives were behind a particular course of action of other parties. I can't speak to that.
Though it's clear that competition lowers prices, so that was an element of competition. This is the last quote I want to put to you. It is clear that facilities-based competition is unlikely to improve outcomes for Canadians if barriers to entry and expansion prevent or lessen the ability of facilities-based entrants, such as Freedom or Eastlink, to disrupt the coordination between the national wireless carriers. It strikes me it might be problematic, based on your quotes, not mine, if we were to lose a wireless disruptor such as Freedom Mobile.
As I say, Madam Chair, we did an extensive amount of work in the CRTC wireless proceedings. I should flag, as my colleague Mr. Scott has already flagged, that these matters are still before the CRTC, so I don't want to go too far, but we made these submissions. They were backed by evidence, by deep economic analysis where we retained an outside expert. So we stand by what we submitted to the CRTC in terms of competition advice.
In terms of process, one question I have is in relation to the power that you have to block a merger. So based on all of your, no comment on your part, but here's my comment. Based on everything you've said in the past, it is unclear how this merger would proceed as is, apart maybe from Freedom being spun off to another entity. What powers do you have to block a merger that can't be overridden by the government? Is it possible you make a submission, you say, we don't think it should go forward? Do you have the final say, or is it up to the governing council?
Thanks, Madam Chair, and thanks to Mr. Gerson Smith. Ultimately, I have the final say with respect to taking action to block or alter the merger if our review gets us to that point, and that's true for all the mergers that are reviewed by the Bureau. That is, that I can bring an application as Commissioner of Competition to the Competition Tribunal to prevent or alter the merger as proposed, or any merger as proposed.
And if it goes forward and you find over a year from now that it has substantially lessened competition and you made a mistake, can you undo the merger after a year?
There's a statute of limitations in the Competition Act that prevents us from taking action after 1 year.
Do you think that should be changed?
Well, what I can say, Madam Chair, is that I'm a strong supporter of a comprehensive review of the Competition Act in Canada. I've said that previously, publicly, multiple times. Competition is truly the best protection the public has. Competition drives lower prices, increased choice. Competition drives productivity and innovation, which are needed in Canada. So this is an aspect of a comprehensive review by Parliament that could be considered.
And lastly, have you learned anything from the Bell takeover of MTS that you might bring to bear in this analysis?
The Bell MTS matter, obviously the consent agreement in that matter is still in place. Provisions with respect to transitional services are still in place. We are monitoring the compliance with that consent agreement that was entered into in 2017, sir.
Thanks very much. Stay true to your past statements. I appreciate it.
Thank you very much. Notre prochain tour.
Our next turn is MP Lemire, 6 minutes. Thank you, Madam Chair. I'll begin with Mr. Boswell from the Competition office. On the 29th of March, Mr. Joe Natal of Rogers said that the ability of uniting both teams will allow Canada to play a leading role in the digital economy. With Rogers' acquisition of Shaw, in his opinion, would that merger allow Canada to play a leading role in this digital economy in the world, or will this represent a setback in competition and that there will be negative repercussions for the digital and economy in Canada?
Thank you, Madam Chair, and thank you to Mr. Lemire for his question. What I can indicate, sir, is that first of all, not appropriate for me to comment on what others have said at this time. And what we will be doing is conducting a thorough, deep review of this transaction to determine whether or not it's going to result in a substantial lessening or prevention of competition in Canada. That's the work we're going to do. And it may take time, but we're going to do it.
Thank you. I imagine that the points that have been raised in the 4 meetings will take into account what you've said as well. Do you intend to comment soon on this proposed merger? And if there was an alternative proposed, would you be able to adapt to move forward these decisions?
Yes, Madam Chair. Generally speaking, we conduct our investigations, our reviews in confidence, in private, so that we're not commenting as the investigation of a merger, any merger, evolves. Once we've reached the end of our investigation and have arrived at conclusions, whatever they may be, at that point, we will pursue the next steps, and potentially there will be public commentary.
I have another one. In order to maintain competition so that there might be a fourth, fifth, or sixth entity that might exist and create effective means to create competition, what, in your opinion, are the essential components that should be part of the Rogers-Shaw deal?
Yes, Madam Chair. As I say, it's not appropriate for me to comment on the components of the Rogers-Shaw deal. What I can say is that in the past we've made we've provided competition advice in terms of competition generally in Canada and in different sectors of our economy. And of course, we made, as I've already referred to, extensive submissions to the CRTC on their wireless review.
Merci.
Thank you. Question for Mr. Dagenet. Statistics Canada recently published prices on wireless services, and there's been a decrease of 15% over the last 12 months. So what explains that decrease, in your opinion, and could it be threatened by Rogers' acquisition of Shaw? Thank you for the question, Madam Chair. We published, I think, last month or 2 months ago, the fact that prices for wireless services have gone down between 10 and 18%, according to the packages purchased. And I think that the department was in discussions with suppliers of wireless services over the last 12 months. And they had indicated at that time that if there wasn't a decrease of 25%, there might possibly be repercussions in terms of regulations. But as to the merger, I hope you'll understand, Madam Chair, that I will make no comments on the transaction before us, but I'd be happy to talk about the regulatory framework that we will be using to analyze it. I was expecting that. The Federal Minister of Innovation, Minister Champagne, said that he mentions in particular that the objectives of the government in terms of innovation and competition for telecommunications how will you, in fact, set out those parameters? Well, we have what we call a framework that is our guide for the transfer of these assets. And when we look at the framework, Section 40 takes into account the following factors, and I'm shortening it, but you look at the current assets and in terms of specter, the general distribution of specter, the current and potential spectrum, the deployment of the networks, the characteristics of a region, and there are other factors that are relevant as well to support the policy objective. Thank you. And how can the federal government increase growth in the various markets of competition? Well, the government has taken several steps. Oh, sorry. Perhaps during the next turn you'll be able to continue with your answer.
MP Massey, you have the floor for 6 minutes.
Thank you, Madam Chair, and thank you for our witnesses. The Competition Act is barely worth the paper it's printed on for protecting Canadian consumers right now. And I do have some great deal of empathy for the women and men in the Competition Bureau that have to serve under such an archaic version in a modern society right now, especially when you compare that to the United States and some of their issues, which is going through a full review for consumers there. But with that, Mr. Boswell, I do want to ask about some previous decisions of the Competition Bureau and to find out really what the reflection is now or whether there's been further review of what the actions that took place and how they were. So the first would be the Rogers previous takeover of Mobilicity. How did that actually help consumers and push competition? Can you provide some insight on that, please?
Yes, thank you, Madam Chair. Perhaps my colleague, Mr. Durocher, can comment on that particular transaction.
Sure. As with all merger reviews, the legal standard for the review is whether the evidence suggests that there's a likely substantial lessening or prevention of competition. And in that past merger review, the decision was made that it did not meet that standard, and that was the conclusion.
Okay, so then are those decisions then reflective about current analysis? Is that move forward? So and I'd ask that with, you're mentioning your Bell decision with MTS and you're monitoring it. But again, is there an evaluation of that in relation to the decision? So that's the second one of the 30 that I want to discuss.
Yes, Madam Chair, thank Mr. Massey for the question. With respect to an after-the-fact assessment of the Bell MTS transaction, that hasn't taken place. I can indicate that quite clearly. We are monitoring the compliance with the consent agreement. And I should say, sir, that we simply don't have the resources in order to conduct after-the-fact assessments of our merger remedies. The resources we have are going full out on current mergers that we are tasked under the law with reviewing. Secondly, we don't have powers in the Competition Act to compel the necessary information and data from parties in the marketplace in order to properly assess the effectiveness of a prior remedy. I can tell you, sir, that internally, we would like to set up what we call a remedies unit, where we have a center of expertise inside the organization that monitors consent agreements, that goes back and looks at them for their effectiveness, and advises on future agreements. But we simply don't have the human or financial resources to set up that remedies unit at this time.
And to be clear, Madam Chair, this testimony from Mr. Boswell and also previous Competition Bureau representatives of this committee over numerous times have actually, mentioned that in their testimony several occasions. This is not a differentiation from any of the years that I've been here. This is something that has continued to exist. Now, I want to touch briefly on the next one, is the TELUS takeover of Public Mobile. Again, is it in the same context of evaluation parameters and I guess resource constraints and so forth. It just seems to me that there's a pattern here, and it would be inappropriate for, I guess, the Competition Bureau to be expected to give a thorough evaluation of these things later on. But I'll leave it to you to talk about that, because I think there are some consequences here that leave us, and I think, flying blind after these decisions are made.
Yes, well, what I can say is exactly as my colleague, Mr. Durocher, said, is that we apply the tests set out in the law and in the jurisprudence to our reviews, to the facts in any particular matter. And, we're a prosecutorial, independent prosecutorial law enforcement agency. We have to take cases to court and put the evidence that aligns with the tests set out in the Competition Act and the jurisprudence if we're looking to challenge a matter. So those are the, if I can say, sir, the confines within which we work. But I can assure you that the team at the Bureau is dedicated to a thorough review of this particular transaction.
Yes, and I have no doubt of that, actually. It's just that I do want a quick confirmation, though, is that you have less tools legally available to you than in the United States to compel information for review for competition matters. Is that correct? Yes or no?
That's correct. The Federal Trade Commission, one of our counterparts in the United States, has those powers.
Thank you. And if I could move to Mr. Scott. Mr. Scott, just in a general kind of sense, the CRTC has a lot of capabilities. Real quickly, why is it that our prices have been rising and competition has been stifled when the CRTC has had some powers? Is there something we're missing in terms of exercising some type of long-term vision?
Um, I'll thank you for the question, Madam Chair, if I may. I think I have to take issue with the premise of the question, Mr. Messe. The prices are going down. I will give you that they should go down further. It's always in the public interest to see the most affordable rates for Canadian consumers. But just for example, as of 2019, if you look at an offering with 5 gigabytes of data, um, rates decreased about 14% to $49 a month. So they are not going up, they are going down. But I will absolutely agree with you that they can and should go down further.
Thank you very much, Mr. Scott. We'll now start our second round of questions, and the first round for 5 minutes goes to MP Dreeshen.
Thank you very much, and it's good to hear the testimony here this morning. This is sort of the end of our part of the discussion for this acquisition, but of course this is where the other 3 groups are going to be starting the work that is required. But I think with the discussions that we've had here, there should be some alarm bells set out as far as Canadians is concerned. We've heard that the proposed merger agreement will have no benefit to Canadians. It'll reduce competition, raise prices, lessen innovation, and lower services to rural communities. We also heard from a rural mayor yesterday that the merger will do nothing to reduce the gap between urban and rural broadband services, and that we need more competition, not less, and we need legislation to ensure there's a backbone network so that smaller players can hook up to it. And of course, I've heard the testimony this morning saying, well, it's inappropriate to comment on things that have been said because until it comes to your table. Now, with the CRTC, you said there's a notice of consultation that you're going to be dealing with. My question is, are these voices that we have been hearing in this committee going to be reached out to by your organization so that you can hear that? And if not, will the commentary that we have heard in industry committee be something that you will base any of your discussions on?
Thank you, Madam Chair. If I can respond to the question, there's a sort of 2 parts to that. In terms of us taking decisions and upon what evidence do we rely, it is only in the we can only make decisions on information filed with us in the context of a particular proceeding. So to be clear, though, in the context of the current wireless proceeding, where there's an important decision pending, a number of the parties that appeared before you yesterday and in previous sessions were participants in that proceeding and have led evidence. Some have not, and all of them are entitled to their opinions, but we rely on the facts in front of us, and then we'll render a decision as we believe to be in the public interest.
So a similar question then to the Competition Bureau, Mr. Boswell. What can those people that have presented information through our committee expect from you as far as when you're looking at what is taking place?
Yes, thanks, Madam Chair, and thank you to Mr. Drushin. I can tell you, sir, that in the course of our merger reviews, we talked to a very wide array of people and businesses and industry associations, customers, consumer groups, citizen groups, to obtain their views with respect to the transaction. We also have an online feedback form related to merger reviews. I can tell you that that online feedback form has received something in the neighborhood of 7,500 submissions since March 15th, if I have the date correct. We will examine those submissions, take them into consideration. Our reviews are broad, sir, and we examine all aspects of a matter.
And that's great because, as you just mentioned earlier, the Competition Bureau, approved the acquisition of MTS by Bell in 2017. You've said that you're monitoring the agreement. What specifically are you monitoring for? Because if people were to know that, then maybe they could tailor some of the comments to you in such a way that it would be more useful.
With respect to the Bell MTS consent agreement, we monitor for compliance with the provisions in the agreement, which is available to all Canadians on the Competition Tribunal's website to look at, in terms of certain transitional services that Bell agreed to provide to ExploreNet as they took over MTS subscribers as a result of the transaction. So those are the types of things, and making sure that everything is done according to the consent agreement.
Are those issues or are those specifics public?
Yes, the consent agreement, sir. Almost all of it. There may be a section that's commercially sensitive, that's confidential, but the consent agreement is public.
Thank you very much.
Thank you.
Thank you very much. We now go to MP Badaway. You have the floor for 5 minutes.
Well, thank you, Madam Chair. I appreciate the opportunity today, and thank you for allowing me the time on this committee today. I really want to concentrate on Mr. Boswell's comments with respect to a review of the Competition Act, a comprehensive review, which somewhat concerns me because of this very important decision that we're looking at now. And under the Competition Act, we do see that it's federal law governing most business conduct in Canada, and expanding opportunities for Canadian participation in world markets, ensuring that small and medium-sized enterprises have an equitable opportunity to participate in the Canadian economy, and finally, to provide customers, consumers, with competitive prices and product choices. So I'd like to really dig a bit deeper into those comments, Mr. Boswell, with respect to a comprehensive review, some of which may be changed and or needed to make a more proper decision in this case. So, moving forward, what are you looking at? What are you looking at? And please be very specific. What are you looking at in terms of a very comprehensive review tomorrow, and compared to what the Competition Act outlines today?
Thank you, Madam Chair, and thank you, Mr. Badaway, for that question. What I was suggesting, sir, is that a comprehensive review and debate ought to take place in Canada with respect to our competition laws generally. And I don't think that perhaps going through different sections of the Act today would be useful to you, sir. But around the world, what I can tell you is around the world, in our key trading partners, there are extensive ongoing public policy debates about their competition laws and ways in which they could be changed to better reflect the digital and data-driven economy that we all live in now, to consider those issues, consider issues with respect to the standard for merger review, for example, whether there ought to be presumptions in Canadian law with respect to mergers that that parties then have to rebut those presumptions. There are many issues, and my point simply is that it would be of benefit to the Canadian people to take a comprehensive look at this and consider these issues in the modern economy. Now, I have to caveat that in that the policy function is not something the Bureau has. The legislative policy function is with our friends and colleagues at ISED, and obviously with the minister at ISED. But the minister, in a letter to me in May 2019, invited me to consider these issues to make sure the Act and the framework and the investigative and prosecutorial processes were fit for purpose. And we've been engaged in that work with the department since that time.
Now, with that said, much of the discourse around the proposed merger suggests a binary outcome, and it will either be approved or it won't be. Based on past precedent in both telecommunications and other sectors, that's not the case. Can you discuss the range of outcomes that the Competition Bureau might consider for a case like this?
Yes, Madam Chair, and thanks again for that question. It's a good one. After conducting a thorough review, and if we make a determination that the merger will likely result in a substantial lessening or prevention of competition, that determination in any merger review could apply to the whole transaction, could apply to a part of the transaction, and at that point, depending on what the outcome of the analysis is, we can engage in examining what potential remedies would address that issue, which is the substantial lessening of competition, taking that substantial lessening of competition out of the transaction. So sometimes it's divestiture of one part of a transaction. Sometimes it's blocking the whole transaction or seeking to block the whole transaction. It really depends on how the investigation unfolds, sir.
But once again, based on the current Competition Act and the rules that are part of that act, which, as you said earlier, needs a comprehensive review.
The provision with respect to mergers is something that certainly the Bureau works with, and we have the tools to review.
Thank you, Mr. Boswell. Thank you, Madam Chair.
Thank you very much. Notre prochaine.
Our next turn is MP Lemire. You have 2.5 minutes. Thank you, Madam Chair. My question is for Mr. Boswell. You said that your decisions are binding and the minister cannot override them. So I would like to understand. Your report on Air Canada said that Air Transat's report said that their purchase by Air Canada would have been bad for competition. That didn't prevent the minister from saying yes. So why would it be different in the Rogers case?
Yes, Madam Chair.
Thank you, Madam Chair.
Lemire for that question. The Air Canada Air Transat transaction was a different type of transaction than a normal merger review. Under the Canada Transportation Act, the Minister of Transportation can determine if a merger involving transportation undertakings is worthy of a public interest review. And if the minister makes that determination, then the Bureau's role is different. Our role at that point in time is to provide advice to the minister on whether there are potential competition concerns with respect to the transaction. The minister takes our advice into the mix of public interest issues that he or she is considering, makes a recommendation to Cabinet, and Cabinet makes a decision. So that is one of the rare instances where the Bureau doesn't have independent decision-making with respect to a merger. In that particular case, you're correct. The Bureau I provided a letter to the Minister of Transport at the time indicating that the Bureau's review suggested that there would be a substantial lessening of competition as a result of that transaction with respect to 83 different routes. That is origin destination pair routes between Canada and Europe and Canada and southern vacation destinations. Subsequent to that, the minister then seeks advice from the Bureau, from me, with respect to any remedies, and we provided that advice. So it's a different situation, Mr. Lemire.
Merci beaucoup.
Thank you very much. That answers my question well, and thank you very much. Thank you.
Questions goes to MP Massey. You have 2.5 minutes.
Thank you, Madam Chair. Back to Mr. Boswell with regards to the year-long, I guess, a review that you're able to have. How does that compare with the United States and Europe? I'm just curious about that. You have a year to do that, and how does it compare to your peers?
Yes, Madam Chair, that statute of limitations doesn't exist in the United States with respect to merger transactions. They can go back after a period of time and re-examine them, reopen them. And that has taken place in the United States. It's not something they do lightly, obviously, for the business community, but there is no 1 year. I cannot say, sir, with certainty what the situation is with respect to the European Commission Directorate General on Competition. Perhaps Mr. Durocher or Ms. Wright can chime in on that if they know the exact answer.
I'm afraid I'm of no assistance with respect to that question either.
That's okay. I mean, our best comparative is here with the United States anyways, given our integrated economies and so forth. I think members here see a trend developing with regards to consumer protection and competition in Canada versus a country where we have quite a bit of connection to economically, socially, and culturally. If I could now move quickly back to the CRTC, with regards to your, I guess, resources, do you feel, Mr. Scott, that you have appropriate resources to compel decisions in a quick and timely manner? The odd timing of this takeover merger towards a spectrum auction puts a squeeze that's untenable for everyone. But I'm also just curious, past that, do you have the capabilities to do quick and orderly reviews for yours?
Madam Chair, thank you for the question. I'd be lying, and Mr. Seidel, who runs the telecommunications branch, will probably come and threaten me thereafter if I said, no, we're all good. We have tons of resources. We are fully deployed. We are very, very busy, but we have adequate resources. These are large, complicated proceedings, and they do take a long time. And the COVID situation prolonged it as we made sure that carriers that were part of our proceeding had the necessary, the requisite focus on ensuring that services to Canadians continued and they weren't preoccupied with meeting our deadlines. But generally speaking, we do have the resources and we do render timely decisions, recognizing that this has been a long process.
Thank you very much, Mr. Scott. Our next round of questions will go to Député Généreux. Vous avez 5.
MP Généreux, you have 5 minutes. Thank you, Madam Chair. I would like to thank you to all the witnesses for being here today. Mr. Scott, about the CRTC. I heard several comments about the CRTC, some better than others. But one thing that Mr. Natali of Rogers said, that when 5G arrives in Canada, it was a milestone, it was a cornerstone of technology in Canada. So I'd like to ask you, in your opinion, because he compared it to the arrival of cable and even internet at the time, and for recent generations, these have been hugely important to the development of our society in Canada. So in your opinion, would the arrival of 5G truly be a significant cornerstone in the development of technology in Canada? Very briefly, yes. I think that 5G technology is really, I don't know what the word is in French.
A step function change. It is not only the speed, but the nature of applications and the proximity of devices to their antennas. So it will permit a wide range of applications that don't exist today.
OK. Dans mon comté de Montmagny,
Okay, in my riding, in Montmagny, people are are on 1G. They're a great long ways away from 5G. So there aren't many players in the domain, and it makes this whole issue really difficult. And I'm speaking to the people also who are responsible for delivering spectrum licenses, but this is a fundamental issue, this delivery of these services to all regions of Canada. We know that there are vast territories with low density of population. Do you think that at the cost we pay in Canada, it's reasonable, or do you think they're too high, or completely unreasonable? You are in a good position to tell us about this because you have certainly heard complaints. And in fact, I'd like to know if you've had complaints about prices in Canada. I'm told that we pay way too much in Canada. So is that true? Thank you, Madam Chair. And perhaps I could share the answer with my colleague from ISED on the issue of spectrum.
Let me answer the last part first, which is, are prices too high? I think the question is, should they be lower? And the answer is yes. And I'll always answer that. It is to the benefit of Canadians to have the lowest possible prices. As to the deployment of services, that's one of the reasons that we have a discrete broadband fund, and the CRTC's broadband fund can also be used and is also used to deploy or support the deployment of wireless services to cover highways and secondary highways. So we are endeavoring to do so. The question of spectrum, I would defer to my colleague, Mr. Dagenet.
pour le Monsieur Dagenet, pour le
Well, Mr. Dagenet, for spectrum, we've heard within this study that we're carrying out, but also outside of it, I've heard that spectrum has been purchased by businesses that in fact didn't use them, but bought them because it added great value to their business. And I think Shaw might be a part of that, and that might be part of the transaction we're discussing today. So is it normal for businesses to have access to spectrum that they won't even use or are not using? No, thank you very much, Madam Chair. Sorry. When we have spectrum auctions, we do attach to conditions concerning the deployment. So if we're thinking about the auction that's going to take place in a couple of months' time, there are conditions that we have been looking at over the last 5, 10, 20 years to ensure that people who buy the spectrum can't just set it aside without using it. Ultimately, the main goal is to put the spectrum in the hands of people who will use it and provide services to Canadians. And if they don't respect those deployment conditions, we do have the option of withdrawing the license. Have you ever withdrawn any? We've already had many discussions with internet service providers and telecommunications businesses on regarding these conditions. So you're saying they've always been respected? I said we've had several discussions, and following the discussions, it has been resolved. Well, you'll understand that, well, Madam Chair, I think your card's changed color on me. Thank you very much, Mr. Généreux. It's possible you'll have a chance to come back on a fourth turn, so there'll be some time left.
Harry, you have the floor for 5 minutes.
Thank you, Madam Chair, and thank you to all the witnesses for your testimony today.
If I may start with Mr. Boswell. Mr. Boswell, yesterday, as I'm sure you heard, a representative from the CNOC, Madam Chabon, raised some concern, expressed some concern regarding the efficiency defense. And she indicated that the use of efficiency defense may render this whole process of review, fruitless. So can you share with us what are your thoughts on that and the applicability of the efficiency defense in this case? Thank you.
Yes, Madam Chair. Thanks to the member for that question. The efficiencies exception is set out in Section 96 of the Competition Act, and it's available for use on any merger in Canada. And effectively, it says that where efficiency gains are likely to be brought about by the merger and are greater than and offset the anti-competitive effects, then that will carry the day. And even if there's a finding of substantial lessening and prevention of competition, the merger will be allowed to proceed. Now, that's in the Competition Act today. My job, which I took an oath to do, is to administer and enforce the Act to the best of my ability. So when it comes to the efficiency exception, it's something that does come into play. The onus, I should say, is on the parties to prove the efficiencies. There are sort of 5 layers that they have to go through to establish what we call cognizable efficiencies. And they have to prove that either at the competition tribunal beyond a balance of probabilities, or they can advance the efficiencies exception with the Bureau, and I'm talking generally here, with the Bureau in connection with our merger review. But we've been very clear lately, I've been very clear that this is a very, very serious exercise of enforcement discretion to approve an otherwise anti-competitive merger based on the efficiencies exception. So we've made it very clear in a model timing agreement to parties that if they're going to rely on the efficiencies exception, they are going to have to commit to provide the Bureau with ample time, reasonable time to thoroughly scrutinize the efficiencies they're advancing, to cross-examine under oath representatives of the merging parties to really dig down on those efficiencies. But it is a reality in Canada's Competition Act, and it is Canada is really the only country that has this particular specific provision that allows an otherwise anti-competitive merger to go forward based on efficiencies.
Is this an area that you're going to consider reevaluation when the Competition Act is up for review?
Madam Chair, what I can tell the honourable member is that this particular provision of the Competition Act has been the subject of significant debate since it came into place in 1986. It's controversial, both inside and outside of Canada. And certainly, from the perspective of the person who administers and enforces the Act, I think it would be worthwhile in this country to discuss this particular section of the Act. And that's for parliamentarians.
Okay, thank you. So I got about 45 seconds left. I'd like to quickly go to Mr. Scott. Mr. Scott, yesterday we heard from Mr. White that there are 2 sections, specifically Section 7 and Section 24 of Telecommunication Act, that would is the solution for a quick evaluation of this merger. What are your thoughts on that?
I'm a bit at a loss to answer the question because the Commission does not have the authority under the Telecommunications Act to review transactions, changes in ownership. So I apologize. I did review the blues from yesterday. I don't recall that, but it's mistaken if it was suggesting that the CRTC has the authority to review or block a change in ownership, but for being disqualified for reasons of foreign ownership.
Thank you.
Thank you very much. We'll now start our next round of questions. First round goes to MP Baldinelli. You have 5 minutes.
Thank you, Madam Chair, and thank you to the witnesses for being with us this afternoon. My one colleague, Mr. Jahari, essentially stole all my first questions with his regards to Commissioner Boswell and the notion of Section 96 and the efficiency defense. And I was going to pursue that line of questioning, indicating with regards to what other nations may have that type of section within their legislation. So thank you for answering that and the whole notion of a comprehensive review, which I understand that you say you're open to doing and looking forward to seeing happen. Now, also, Commissioner, if I can just follow up with you, I believe you met at this committee in December, and you testified that the Bureau is facing some challenging resourcing and resource constraints, stating notably the Bureau's budget fell by almost 10% in the last 10 years in real dollars. Now, do these constraints extend to the merger review process? And how has that hindered your the Bureau's ability to undertake significant reviews such as this?
Yes, Madam Chair, thanks to Mr. Baldinelli for that question. Yes, as I've said before this committee and publicly multiple times, it's clear that our agency is stretched in terms of resources. The demands on our limited resources have significantly increased just in the last few years with the digital economy growing by leaps and bounds, a data-driven economy. So it's put a tremendous stress on the organization in terms of our investigations. Just to illustrate the point, I can, in between 2017-18 fiscal year and then the next fiscal year, we obtained an additional 4,459 gigabytes of data in our investigations. Now, 1 gigabyte of data, committee members, equals enough to fill a small truck, or 678,000 pages approximately. So in 1 year, the increase in the data that we are reviewing as part of our many investigations, we have other enforcement areas other than mergers. The amount of data brought into the Bureau related to those reviews grew by 3 billion additional pages. Wow. Now, that's in the context of our budget having been flat for 10 years. And if in fact you take into account inflation, declined by 10% over that time. In terms of this review, we will allocate and prioritize internally to allocate the resources necessary to conduct a thorough review of this particular transaction. I can assure this committee of that. We do that all the time at the Bureau. We have to prioritize, we have to move resources around in order to do the best possible job we can to protect the public interest and protect Canadians' interests.
Thank you for that. But quickly, to your point, so if this ends up being prioritized, do other reviews get delayed or held back and work is not performed at all on certain issues which many others would say is a priority to them?
Yes, it is always a tricky exercise to prioritize and reallocate internally, and sometimes we have to leave certain aspects of our work, important aspects of our work, to not be as advanced. Specifically, sometimes we have to pull back on some of the important competition advice we provide to regulators and governments at all levels in order to put those resources towards enforcement work, and to reallocate in other ways. But it's not, it should be clear, it's not always another case gets hurt specifically because of one case.
Thank you. I'd like to ask Mr. Scott now on the basis of the CRTC and your comments earlier about public hearings. Now, are public hearings held in regards to a merger such as this? Are they automatic or are they held at the discretion of the CRTC, deciding what should be held in terms of hearings?
There's the requirement for a process, and whether or not that process is more administrative in nature or whether it requires a full public proceeding is at my discretion. Effectively, there's no question in this case that a transaction of this magnitude requires a public proceeding, and there will be one.
Thank you. And thank you, Madam Chair, for your
Thank you
time.
very much. Our next round of questions goes to MP Lampropoulos. You have 5 minutes.
Thank you. Thank you to our witnesses for being with us today on this call to answer our questions. My first question is going to go to Mr. Boswell. In general, I think all of our witnesses that have come and testified for this study so far have said that this merger is definitely one that would not be good for competition, except of course for Shaw Rogers themselves. But everyone else has said that this wouldn't necessarily be good for competition. And you have stated today that while you're not really able to specifically speak to the case at hand, that many of the factors contributing to whether or not this would decrease competition are being looked into and are being considered. And so I'm hoping that means a good thing for Canadians. Now, let's just say that a merger, not this one, was to not be approved by you. What would these companies be able to do to bypass this? And are you the one who makes the final decision? And you had said that if it were accepted, I think I misunderstood a little bit in your testimony earlier, but if someone were to receive the approval, you can then take it to the competition tribunal and then they would be able to counter this. Can you explain a little bit further and in more detail how that works?
Thank you, Madam Chair. Happy to provide that explanation. We're tasked with, as I've said repeatedly, assessing the merger to determine whether it's going to result in a substantial lessening or prevention of competition. That, generally speaking, involves looking at a whole bunch of issues in cases, talking to all sorts of industry participants, customers, consumers, retaining experts, and all driving towards analyzing the merger, whether it's all aspects of the merger or specific aspects where we have serious competition concerns. At the end of that process, we'll come to a conclusion, whether or not the merger will result in a substantial lessening or prevention of competition. At that point, we can communicate that to the parties and indicate that is our finding, and engage with them in potential remedy discussions. That is what they could do, and I'm speaking generally here, what they could do to address those concerns. That is what could take away the substantial lessening or prevention of competition. If those negotiations don't work, then it would be up to me to decide if we file an application at the competition tribunal to challenge the merger. Those are sort of the binary decision points as you go through the matter. Either if we get that conclusion that it's going to substantially lessen or prevent competition, we can negotiate with the parties and come up with a resolution, a remedy that we believe fixes the problem. Or if we can't negotiate that, we go to court, effectively the competition tribunal. We put our case forward and the parties put their case forward, and it's up to the competition tribunal to decide. There is no, we're independent. These decisions, I need to stress, these decisions are made independently. The government and ministers are not involved in my enforcement decisions.
Okay, thank you very much. And to the Department of Industry, what could be done to support, I guess, the Competition Bureau in this task? What can we or what can the government do to ensure that a merger that would decrease competition, basically go ahead. I know that we just concluded that this is a competition tribunal decision in the end, but what extra support can ISED or can the government or the Department of Industry offer?
Thank you for the question, Madam Chair. I think it's important to understand, one, that the Competition Bureau is independent and their decisions are arrived at independently, and I think Mr. Boswell's laid that out. The Minister of Innovation is really looking at the spectrum concentration, the transfer of spectrum licenses. So when the minister looks at that, he's really looking at the wireless assets here. So in the case of a merger, you would have one applicant that has many spectrum licenses that wants to transfer them to the company that wants to buy them. And that's what the Minister of Industry is looking at and is guided by the spectrum transfer framework.
Thank you very much. Notre prochain tour.
Our next turn is MP Lemire. You have 2.5 minutes. Thank you, Madam Chair. My question will be for Mr. Scott of the CRTC. The man from Videotron said that in order to increase investments in installations that would ensure the development of our telecommunications infrastructure, all partners have to invest in the infrastructure. So what do you think of this proposal that seems to be a bit the opposite of what the CRTC is putting forward? Thank you, Madam Chair. Thank you for the question, Mr. Lemire.
That question, I think I'll take issue with the premise, but I need to be careful here. Quebecor and Videotron are a part of the wireless proceeding, and they have put evidence in front of us, and we have that under consideration, and we'll be rendering our decision on what we believe is in the public interest in terms of the future regulatory framework for wireless. So I understand Mr. Pelodeau has his views, and he has made them very clear to the Commission in their evidence and their presentations at our hearings. I hope that answered your question. J'espère que c'est...
I hope that answers. Yes. Could we be told when the decision will be handed down on the MVNOs? Because really I can't give you a precise date. Soon. Okay. What do you think of the concept of MVNOs? Do you think that will bring prices down?
Issues that is being considered in that decision, and unfortunately, I cannot answer that question.
And so how are we going to promote the presence of more competitors, fourth, fifth, and sixth entities on a network without giving them some advantages? Well, I'm sorry, that's the same situation for me. It's on the principle that these decisions are before us. Thank you. Thank you very much.
Our next
Thank you.
goes to MP Massey.
Thank you, Madam Chair, and I won't put us through another probing of the efficiency defense. Mr. Boswell, I will say this, though. You're probably the most eloquent way I've ever heard of somebody saying this is the part of my job that really sucks. I mean, this is really clear as to how badly we're being outplayed by our own laws. I do want to move to the spectrum auction and to Mr. Dagenet or to Mr. Scott from Industry Canada. We've heard witnesses say that the spectrum auction should be held off. I think this is one of the problems that we're faced here is that Shaw drops out of the spectrum auction, one of the major players that we'd normally have, and others are saying now it should be held off. This is kind of suspicious timing because it was already delayed by 6 months. Is the department preparing for any of those options? And what are you doing about the fact that a major player, our fourth most strongest competitor, is dropping out altogether?
Thanks for the question. And Madam Chair, the application deadline for participants was yesterday at noon, and we published yesterday late afternoon those that have applied to participate in the upcoming auction. We actually have 24 participants. This is 50% more participants than our previous spectrum auction. which tells me that demand for spectrum and interest in getting their hands on that spectrum is alive and well. So the spectrum auction right now is currently planned to proceed on June 15th, as was previously announced. The only reason it was delayed, as you mentioned, was because of COVID. The industry, really wanted to concentrate on making sure that networks were up and running rather than on the spectrum auction.
So I didn't get a chance to see the list. Is Shaw on that list, or did they bow out of that list? I know that it's been published.
Yeah, Shaw did not apply.
Okay, so I mean, how many times in the previous spectrum auctions did Shaw do apply? Do you just kind of? I know you may not have a specific number, but wouldn't they be assumed as a usual player in the spectrum auctions? Is that fair to say?
I think that's fair to say.
Okay, so I only have 30 seconds. So you know what, I went over last time, so I'll see that to the rest of the group. Thank you, Madam Chair, and thank you.
Thank you very much. Our next round of questions goes to MP Polyev. You have 5 minutes.
Thank you. My question is for anyone over at the Competition Bureau who cares to comment. And it's a broader issue. We've been talking about the need to reconsider, perhaps review the Competition Act. But, that act is designed to have government intervene to ensure there is competition. But what about all of the industries for which it is government intervention that is blocking competition in the first place? The Fraser Institute just published a report showing that something like 35% of our economy is protected against open competition. They list postal services, telcos, maple service, aviation, broadcasting, taxis, liquor, just to name a few. And there are countless others that I haven't had time to list. What does the Competition Bureau say about the countless interventions by all three levels of government to block competition and prevent workers and consumers from benefiting as businesses compete for them through higher wages and lower prices?
Yes, Madam Chair, I guess I'll field that one from Mr. Polyev, and thank you for that question. We've actually done a tremendous amount of work in this area, advocating for regulatory reform in Canada to allow for more competition. We put out a competition assessment toolkit that we encourage all levels of government, as you say, sir, to examine their regulations with a view to reducing or eliminating regulations that impede competition, because this can open up our economy, drive productivity, drive growth. We've done a ton of work. I've spoken on this publicly in speeches where sadly I've pointed to an OECD indicator, sir, the product market regulation indicator, which at the last version of that in 2018 put Canada in second last in the OECD in terms of regulatory barriers to competition. And we've also advocated publicly that Canada ought to consider following the Australian model of a productivity commission that they had in the 1990s, which really focused in on these competition issues, made significant changes, and drove significant increases in their GDP.
Understandably so. That's what trade does. Trade forces businesses to compete for workers through better conditions and higher wages, and to compete for customers through lower prices and better products. Absent competition, the fat cat CEOs and shareholders can sit back and milk the system with governmental protection, as they are now doing. Huge cause of wealth inequality. As everything from skilled and qualified immigrants are banned from working in their sector because the professional bodies won't let them work, get a permit even when they're qualified. When we're arresting people for simply taking liquor across interprovincial borders, a really disappointing ruling by the Supreme Court, which decided not to enforce Section 121 of the BNA Act, which allows us as a constitutional right to take produce across our interprovincial borders. And according to one study, by Trevor Tom, economist, this is costing $6,000 per year per household in Canada. And that's recurring losses of income and consumer product benefits every single year. Can you speak further about how we can take urgent action to practically break down these government obstacles to competition in our economy?
Yes, Madam Chair. What I can say is that we have put out this competition assessment toolkit. We would encourage governments at all levels to embrace it, to review their regulations with a view to taking away regulations that unnecessarily, there are other public policy concerns at play, but if it's not necessary and it impedes competition, then amend the regulation, take it out, and allow competition to flourish in Canada.
Yeah, when it comes to these government obstacles, if it's not necessary to do it, it's necessary not to do it. So I will take a careful look at this toolkit, sir, and thank you for speaking out on this, because right now the biggest obstacle to competition in general is interventionist politicians and bureaucrats egged on by self-interested lobbyists who want to keep competition out to keep their profits up. Thank you.
Thank you very much, Mr. Polyev. And our next round goes to MP Assasi. You have 5 minutes.
Thank you very much, Madam Chair, and thank you ever so much to all the witnesses. It's been very helpful listening to all of you. Now, if I could start off with Mr. Boswell. Not only today, but on a previous appearance before this committee, you did talk about resource management challenges. So given that this particular proposed acquisition is what would be referred to as a blockbuster one, I was wondering if you could provide us some approximate time frame as to how long you think this particular review will take insofar as the Competition Bureau is concerned.
Yes, thanks for the question. Madam Chair, what I can say is that first and foremost, we're going to conduct a thorough review. We're going to look at all aspects of the transaction, all areas where the parties overlap horizontally or vertically, and dedicate the necessary resources to analyze those. If necessary, we'll bring in outside experts to conduct economic modeling, those sorts of things. And we'll reach out to a variety of participants, as I've already said several times. How long that's going to take, sir, I cannot predict. It depends where the evidence takes us. That's what we do as an evidence-based organization that has to prosecute cases. We have to follow the evidence.
Okay, so no approximate time frame. Approximate, really approximate.
As expeditiously as possible, if that's an approximation.
Okay, fair enough. Now you spoke of thoroughness, and you also talked about how your mandate and the mandate of the Competition Bureau is to look at market power. Now, in terms of market segmentation, given that we know that Rogers is highly concentrated in places such as Ontario, Alberta, BC, a province such as Ontario, how many market segmentations are we talking about? Because you don't take the entire province as one market, you slice it and dice it. So can you provide us some guidance on that aspect of the work that the Competition Bureau will be undertaking?
Yes, well, what I can say is that it's not appropriate for us to comment on how this particular investigation might unfold. I think it might be useful for you, sir, if we shed a bit of light on how we went about our submission to the CRTC in that wireless proceeding. Once again, we can only say a limited amount in that because it is still before our colleagues at the CRTC. But my colleague, Ms. Wright, was the lead on that matter, and perhaps she can just give a brief description of how we looked at markets and areas there.
Thank you, Commissioner Boswell. So when we're looking at segments of the market, we take a look both at the product market as well as the geographic market. on a geographic basis, what we looked at in the wireless market was either local or city. So city's a little bit broader than local. And those were the two geographic markets that we were looking at in the wireless sector. When we took a look at product market, what we found was that you don't actually have to differentiate between products, because regardless of what product you're looking at in the wireless sector, regardless of what size of plan you're looking at, consumers generally have the exact same choice. And so it doesn't really matter on the product market side. On the geographic side, we're looking at either local or provincial. Sorry, local or city.
Thank you. Now, my last question for Mr. Boswell, and you've confirmed all my suspicions. I knew that if you would appear, it'd be difficult for us to get a lot of information out of you in the interest of maintaining neutrality. But could you perhaps talked about negotiations at the end after you've done your analysis and the possibility of divestitures? Can you elaborate on that particular process and give us all a better sense of what that will entail, the divestiture process?
In 15 seconds, given Madam Chair's yellow card, essentially in all merger reviews, if we get to a conclusion where there is a substantial lessening of prevention of competition, we engage with the parties to see if we can negotiate an acceptable settlement to address the competition concerns to protect Canadians.
And the one case where you ordered the highest number of divestitures would be?
Red card, don't know off the top of my head.
Saved by the red card. And with that, we have a little bit of time remaining, so I'm going to give one slot to each of the parties so that they can ask some final questions. So with that, we'll start with MP Généreux. Vous avez 5 minutes.
You have 5 minutes. Thank you, Madam Chair. Mr. Scott, would you agree that more competition brings more variety, but also, generally speaking, lower prices? Yes, generally speaking. Is the fact that you have to oblige businesses like Bell and Telus to offer bulk services, if I can refer to that in a way, to resell them, that Mr. Pelado referred to as parasites? I think it's 83% cheaper, so that they can be competitive in markets where big players weren't present. So have you seen, and perhaps other witnesses might say, have you found that this has allowed for a decrease in prices in certain sectors? Perhaps Ms. Wright could answer also. Well,
once we start talking about specific situations, that is an issue. The issue of MVNOs and resale in the wireless segment is one of the core issues in the proceeding that's before us. And I will take a moment to acknowledge the Competition Bureau's extensive work in providing a major submission and analysis in that work. But as I said, the decision is forthcoming, and it wouldn't be appropriate for me to comment on such a significant element, such a central element.
Madame Wright, est-ce que vous pouvez...
Ms. Wright, could you add something, or are you in the same situation as Mr. Scott?
What I can add is essentially what we've put forward in our submission. And so one of the largest findings in our submission is that when you have a market with a strong regional competitor present, you will find that there are price drops in the range of 35 to 40%. And so the remedy that we suggested to the CRTC was a remedy that was intended to make that price competition happen in more markets across Canada, so that more Canadians can benefit from that type of competition and that type of price lowering.
Alors, pourquoi est-ce aussi difficile pour...
So why is it so difficult for the third player like the Rogers group, for example, to break into the market because they're very interested in doing so, as I've heard. And would that not be to that would be to the advantage of Canadian consumers? So why don't we see more of that, Ms. Wright? Unless Mr. Desrochers or other witnesses might want to say something.
To answer that question. So our analysis in the wireless sector for the submission that we made to the CRTC was really focused on how do you get more regional players into more markets across Canada. And what we found is that facilities-based competition is the best type of competition. And that means that we put forward a remedy that focused on creating an MVNO framework that would allow for facilities-based competition, which is the most sustainable type of competition in the long term in Canada and will result in the lower prices for Canadians.
Madame Wright, je sais pas si vous avez étudié
Ms. Wright, I don't know if you looked at the testimony of our previous meetings, but it's people are not in agreement with you, that's for sure, particularly the big players. Are you aware of that?
Yes, we are aware of that. Essentially, MVNOs are competitors who have to rely on their competitors for a necessary input into their business. They're relying on their competitors to access spectrum. If we can create a way for there to be independent competitors in the marketplace, so they're not relying on anyone else in the marketplace, they're able to control their prices, they're able to control their network quality entirely, then we can potentially see the same type of price decrease that we saw in our analysis, which was up to 35 to 40% if you can get a strong regional player into the market.
Madame la Présidente, je vais...
Madam Chair, I'm going to propose a new study or a new analysis that might allow us to see how Canada can go out and look for more competition. Thank you very much to all of you. Thank you.
The next round of questions goes to MP Badaway. You have 5 minutes.
Thank you, Madam Chair. And I do want to get back to the two previous speakers, but I think that has to be prefaced by a question. And I'm going to give this question to someone that I haven't heard much from today, the Department of Industry. I do want to ask that the government has enacted pro-competition policies by setting aside spectrum for smaller regional carriers. But there's a fear that if Rogers were to acquire Shaw, they would then get that set aside spectrum at a cheaper rate than of course, had they bid on spectrum themselves. So could you please explain further how spectrum transfers and the work involved and the types that would be allowed, denied, or forced to sell?
Yes, thank you. Not a simple question, but I'll try to provide a simple answer, Madam Chair. Essentially, what the minister would look at in the context of a merger would be looking at spectrum that's being transferred from one party to the other, and be looking at spectrum concentration in the different license areas. So we would be looking at it license by license areas to look at the availability of spectrum to other parties. In the specific case of Shaw Rogers, while I've said I won't comment on the transaction, some of this is on the public record. So if we look at our previous 600 megahertz auction, which took place in early 2019, we had some set aside spectrum, and Shaw bid on it and won some licenses. The minister issued those licenses with conditions attached, and those conditions included a prohibition on the transfer of those set aside licenses to incumbents for a period of 5 years. So that's one way in which, when we have set aside or competitive measures to encourage competition in the wireless market, it's one of the measures that we typically put in place to ensure that the kind of scenario that you describe doesn't take place, or at least doesn't take place in the immediate years that follow, and that it's not an opportunity for arbitrage.
Thank you, Mr. Dagenet. And I go back to Mr. Genereux's comments with respect to Ms. Wright, with respect to getting into areas that sometimes might not be as advantageous for the bigger players, and then therefore allowing all players to have an equitable, I guess, stage to stand on. So to Ms. Wright, you mentioned the fact of having the ability to get into areas, and although, as Mr. Generous said, the big players don't like it with respect to the market share, but do you find it in the direction that you spoke about? Do you find it advantageous for rural communities to actually have these capacities offered to them uh, where they don't now, and as well at affordable pricing?
Thank you for the question. Madam Chair, our analysis was really about trying to get competition out to every community in Canada. And we found that if you can get strong regional players into every community in Canada, Canadians can benefit from the competition that we're seeing in particular areas of Canada. When it comes to rural and remote areas of Canada, oftentimes it's difficult to both build a network at this when you don't have a customer base. And so our proposed remedy to the CRTC focused on allowing regional players to access spectrum from incumbents for a period of time while they are building out their network. That would allow them to develop a customer base um, while at the same time building out a network and then transitioning to their own network so that they would be an independent competitor in that marketplace.
Thank you, Ms. Wright. And I guess, again, to the same comments or questions that I had from Mr. Boswell earlier, do you find that the current act allows you and others that are on this panel the ability to actually bring forward these recommendations in a manner of which they will be done, they will be not done, they will be the possibility that there might be a challenge. Do you find that again that those opportunities are present now, or that there should be in the future some adjustments made to the act?
I can speak specifically to um, the proceeding in front of the CRTC. What was extremely helpful for us in making the recommendations that we made to the CRTC was the ability for us to get data from market participants so that we could do our analyses and base our recommendations on those analyses.
Thank you, Ms. Wright. We see the red card. I feel like I'm in a soccer game. I'm getting tossed out of the game now. Thank you, Madam Chair, and thank you, Ms. Wright, and thank you to all the participants.
Rest assured, MP Badaway, there's no challenge on the field. Thank you so much. Our next round of questions goes to Député Lemire. Vous avez 2 minutes et demie.
Mr. Lemire, you have 2.5 minutes. You'd be hard to throw Mr. Badaway out. I'll carry on with Mr. Scott of the CRTC. Because of the acquisitions by Shaw by Rogers, do you think that you'll make changes to the spectrum auction for 3,500 megahertz?
Je m'excuse.
I'm sorry, I was muted. That's really not our decision. That's one for the minister to make. Yes, but your opinion would be interesting. In your opinion, should Shaw be withdrawn from that particular spectrum auction if they're with Rogers, or are they still eligible? Well, once again, if the question to me, it really is perhaps a question for Mr. Dagenet. Well, we could ask him the question, but I'm interested in your opinion. Once again, I can't answer that. That's really not our file, and nor is it our responsibility. These are the policy objectives for spectrum auctions are to ISED. Madam Chair, thank you for the question. As I was saying earlier to MP Mass, the deadline for people who wanted to participate in the auction was yesterday. And yesterday afternoon, we published a list of the people who applied to participate, and Shaw was not one of the suppliers who wanted to participate in that spectrum auction. So the question is settled. But they would have been eligible. Well, they didn't apply. Well, just for future reference, could we be told if they would be eligible or not? Well, I can say that there are rules as to who is eligible or not in terms of mergers and who's independent and who is not. So I think certain parties can't participate independently. Thank you. Mr. Scott, in terms of brands like Fido who compete and with their bigger players, do you have any opinion on what impact they might have on the competitive market?
Apologize for not apologize, but I'm forced to respond in the same way. The issue of the brands and of MVNOs is central to our proceeding, and the decision will be out, shortly.
Merci beaucoup.
Thank you very much.
We'll go to MP Massey. You have the floor for 2.5 minutes.
Thank you, Madam Chair. Over to Mr. Dagenet. With regards to the spectrum auction, was there anything done different or unique with regards to this one that you can comment on, or was it basically a continuation of policy?
There's a few things that we've done differently. We've gone to smaller tier sizes. So rather than auction off 17 licenses, we're auctioning off 172 licenses. So smaller players will have, we think, better access to smaller geographic areas when they're buying spectrum. So I think probably end up in a diversity of players, and we see it from the number of players that have applied to participate in the auction. We have a lot more than usual. We've also put aside competitive measures, so there's a set aside for new entrants, which is something that is a continuation of policy, but it's an important policy, and I think it's something that is, that the Competition Bureau has pointed out, when there's a strong regional player, you see lower prices. And then the other thing that I would point to is we have pretty, I would say, aggressive deployment conditions to ensure that those who end up buying the spectrum really abide by use it or lose it policy. And so these are, I think, improvements that we've made over the years, and they're kind of culminating in the auction that's coming forward in 2 months.
What type of a revenue do we expect to get a return on with regards to this auction?
I can't really. We don't make forecasts of revenues on spectrum auctions.
Do you have?
The
do you have one that you can refer to before that? What it got?
Well, which is there an auction in particular that you're looking for?
Well, I've got the rundown of the ones before, but I guess the point being is that we're looking into the billions of dollars here. Is this not correct?
Yes, I think that's a fair forecast. The 600 megahertz auction, which I referred to earlier, which was in early 2019, the government collected $3.4 billion in revenues from that auction.
And do they use and lose it? Is there a time frame on that, or how do you?
We do interval checks after 5 years, 10 years, 15 years, and at 20 years. So all along, we will do a check when the licenses are up for renewal, and before that at 5, 10, 15 years.
Okay, so 5 years is the base minimum.
Yeah, it's the first milestone. We call them milestones. Yep. The first milestone is at 5 years.
Thank you, Madam Chair.
Thank you very much. And that wraps up our time today, and actually wraps up our study for the proposed acquisition. And so I'd like to thank our witnesses for being here today. It was very helpful to get the insight and in terms of the process and what we can expect. So thank you again. With respect to our new study starting, if you haven't already sent your witnesses to the clerk, I suggest that we do so as soon as possible so that we can line folks up. With that, I would like to thank again notre service d'interprète,
our interpretation service, our IT people, our analysts, as well as the clerks for their work today. It's always a pleasure to see you, even during the break weeks. Thank you.
I call the meeting adjourned. you.